recommending the maximum sentence of 5 in, 5 out on the G felony and 3 in, 3 out on the H felony concurrent to one another. The reason for that really begins with something I brought up at every bond hearing we've had, and that's the extensive criminal history of Mr. Standiford. When I look at this case, and I look at the criminal history, and I look at the nature of what happened, I think to myself, if this is not a case where you get the maximum penalty for this offense, what is? I honestly don't know. So if we start the criminal history, we know that Mr. Standiford is 60 years old, and he's got 45 criminal convictions. That means that 45 times now, Mr. Standiford has sat right in that chair. 45 times a prosecutor's made an argument like I'm making. 45 times he's had a defense attorney recount substance abuse and mental health or bad childhood or something like that. 45 times he's asked for leniency. 45 times he's allocated and said he's sorry and he doesn't want to happen again and he's stupid and things of that nature. 45 times a judge has spoken with Mr. Standiford and explained the things he did wrong, what he's got to do different, done in order, saying here's what you need to do different. And here we are again, number 46 and number 47. I think that's very significant because also as you go through the PSI, you see the amount of times he's been revoked on probation. So obviously probation's wildly inappropriate here because there's not a reasonable likelihood he's going to succeed on probation. He's failed constantly at it. Especially when you look at the nature of the convictions, a huge number of them are false name to police, escape, giving name of another, a lot of deception crimes, a lot of evade responsibility crimes. And you pair that with the revocations, it's very obvious that Mr. Standiford does whatever he does to avoid consequences when it comes down to it. I go over this also to kind of illustrate the madness of where we are now, committing crimes, or I have untreated mental health issues and unresolved trauma once we're at 45 convictions and 60 years old. The reality is at this point, you know, the whole basis of knowledge of mankind is inductive reasoning. We know that the sun rises in the east and sets in the west because we've seen it a million times before. As we've seen 45 times before, Mr. Standiford keeps committing these crimes. Probation hasn't done anything, jail hasn't done anything, prison hasn't done anything. He's in his the defense paperwork, he remarks that he's been using methamphetamine for 40 years. And for 40 years, that's been the treatments he's done, the probation he's done, nothing has been to any avail. That's something that cuts against him because it gives the court reason to believe he's not likely to be rehabilitatable. I think rehabilitation in terms of a sentencing goal for this case is in the rear view mirror. It's something that if it were going to be accomplished, it would have been accomplished years and years ago. I think now we are on incapacitation, we're on specific deterrence, and we're on punishment. And for that reason, I think that the maximum is really what's appropriate here. I think the maximum with no eligibility for ERP is really what we should be aiming for here, because I don't see how you could look at these 45 criminal convictions that range from, I counted 5 convictions that were violent of nature, you know, terroristic threats, assaults, an enormous number of false, of lying crimes, I'd call. He's had past check forgeries, one recent, one old. He's had fraudulent transaction card offenses. This behavior is consistent and pervasive. Next, I'd like to move on to talking about the offender's version of not just this case, but his criminal history in general. I think it's very telling that the cases he remembers when he gives his version of his criminal history to the PSI writer are all accounts of how he either didn't do it or wasn't responsible or someone else was really responsible. You know, his Wabasha check forgery, he says, some random guy approached me to cash checks and I did, which is also the same version of events he gave for this one. Some random guy approached me and I went and cashed like $13,000 worth of checks and took a bunch of money. Him saying he didn't know any better when he actually has past check forgery convictions. That's lunacy. He obviously, well, the court shouldn't even believe what that account is. His accounts of his domestic assault is he essentially blames the victim, says she's crazy. His account of his meth case, he says that, well, it wasn't his meth, he just pled anyways. And I think what's most telling, the biggest red flag, is he couldn't account for the vast majority of his convictions. 30-some convictions, according to the PSI writer, he just couldn't know what they're about. And those are convictions with violence in them, convictions of other property crimes, convictions with victims. He couldn't remember the details of a crime that he went to prison for. I think that's a huge red flag, because that's indicating that the consequences he got in those cases, the remorse and guilt a person should feel for doing those things, that didn't hit him like a normal person. It didn't register on him. The only crimes he remembered and could give an account of were the ones where he disagreed with the outcome. Everything else, can't remember. I have too many criminal convictions to remember them, even the ones I went to prison for. I think that's more evidence that incapacitation, specific deterrents are important, because you look at a lot of these convictions and he didn't do a lot of time for them. They put him on probation a lot in Minnesota. Where was I? So yeah, that's something that I think is important to consider as well. I think it's also important to consider, the victim impact statement and the victim's account of what they said to the PSI writer about, this wasn't Wells Fargo US Bank. This is a local community bank. I think they only have a few branches. And they recounted things that I quite frankly didn't even think about. It's not just a blow to a smaller, weaker bank compared to those, national ones. It's also devastating to the workers there. It's traumatic to them that, somebody came in and did this. The way they forged the check to draw out of someone else's account, that also hurts the trust with the consumers. Think about from that person's perspective when they find out from the bank about that. That gives you a little doubt about, the bank's ability to hold your money, which is the reason people put money in the bank, so that it's safe. So there's a lot of negative there. There's a lot of
amount, just for the record, $22,700.75 was the total amount of checks that was written. So $17,700 was what was reimbursed by the insurance company, but Community Bank had to pay $5,000 for their deductible. So it was a total of $22,700.75.
times before figuring out 3 times and getting over $10,000, and before figuring out, this is wrong, when he has those past convictions, when that's the same defense he's using for his Wabasha check forgery case. It shows he doesn't really accept responsibility for this case, just as he hasn't accepted responsibility for any of his past criminal history, according to the PSI. So I just think that given the offense itself, that, he has financially profited off of it, that he has this extensive criminal history, and it's prolific with the dishonesty in it. And I just don't see a reality in which there's any reason to believe that for convictions 46 and 47 today, that this is going to do the trick. Now he's going to get his methamphetamine habit under control. Now he's not going to do more financial crimes. And he's got a bunch of those on his record. I don't see that as realistic. I don't see rehabilitation as a realistic goal. And I'd ask the court to follow the state's recommendation. Thank you.
All right, thank you. Mr. Pollack.
Thank you, Your Honor. As the court knows from reviewing the memorandum that was filed, I am asking the court to essentially impose the lower end of the PSI recommendation, make Mr. Standiford eligible for earned release programming while in prison, and impose essentially on count 1 a 4-year prison sentence consisting of 2 years of initial confinement followed by 2 years of extended supervision to run concurrent with the count 11, where I'm asking the court to impose a sentence of 6 years in the Wisconsin State Prison consisting of 3 years of initial confinement, followed by 3 years of extended supervision with eligibility for the substance abuse program concurrent to count 1. I would ask the court to stay count 1 for 3 years of probation and stay count 11 for 5 years of probation. I want to begin by pointing out that Mr. Schmidt is correct in the sense that this is a rather sophisticated operation as it relates to the manufacture of checks that draw upon business accounts. There is certainly sophistication there. I think Chief Tex actually noted that on page 3 of 29 in the PSI, that there was more than likely a third person involved who orchestrated this crime and was knowledgeable. That is consistent with Mr. Standiford's version of events. That is consistent with, I think, the indication that Jamie Blackerby was also arrested as a result of this crime. I don't know Jamie Blackerby. I've never spoken with Jamie Blackerby. Mr. Standiford represents to me that he has never met or spoken with Jamie Blackerby, and I have no reason to disbelieve him. I think that this was certainly a sophisticated operation orchestrated by an individual or individuals who had the technical know-how and ability to generate very sophisticated fake checks that I don't think, if I'm reading the PSI, the community bank and siren doubted for a minute. That is certainly a problem. And again, I don't know Jamie Blackerby, but I do know Mr. Standiford, and I'm assuming they have several things in common. Mr. Standiford, as pointed out, has a 40-year history of methamphetamine addiction. He is regularly homeless. He is the sort of person who would be drawn into a situation like this. That does not make him less responsible. He takes responsibility. And as Mr. Schmidt noted, he prepaid $5,000 in advance of this hearing. That was the amount that was requested to make the victims whole. He did not gain anything from that except the opportunity to tell the court here today that he has done what he can to make the victim whole. He's posted a significant amount of money. He does have family here supporting him, which I think goes to his character and credit. One thing that I think Mr. Schmidt did not discuss, which I don't know why he would have to, but I do think it's significant as it relates to both the character of Mr. Standiford as well as the need to protect the public. Everything we know from these documents indicates that this was brought on following a very severe health emergency. Mr. Standiford had, I think, 2 strokes, and I have medical records that my CSS representative relied upon to draft her sentencing memorandum. He is now lost an ability to work. That's placed him on disability. He's probably thinking that, and I know he was thinking that his life was probably in danger, probably close to an end. He was rock bottom, despair, and he was brought into this insane case. So he will probably tell you more about that, it sounds like. I think to Mr. Schmidt's point about the need for detention and incarceration, this was a case where the court issued a warrant, and I had the date up, I think, in June of 2023. I contacted the Ramsey County Warrants Division because Mr. Standiford was arrested in Ramsey County, Minnesota. He was arrested on July 30th of 2023 prior to his arrival at the Burnett County Jail on August 16th of 2023. He has remained in custody continuously since that time. So I think he does have rehabilitative needs as demonstrated by a lengthy period of substance abuse issues, addiction. There's kind of conflicting accounts of his childhood, but as Mr. Schmidt noted, it does seem like he had traumatic events in his childhood stemming from his relationship with his stepfather, who unfortunately passed away during the pendency of this case, as did his mother. That has profoundly impacted Mr. Standiford. His entire goal now is to get into the treatment program, get his stable housing set up, repair his relationship with his daughter, and become a grandfather for his 2 grandchildren. So that's everything I had.
Thank you. I see that you have something written on paper. You can read it, but please read it slow, enunciate your words, because we do have a court reporter who is taking down everything.
Your Honor, the past 7 months I've sat in jail, I've done nothing but reflect on why did I agree to cash those bogus payroll checks for virtual strangers, because I didn't receive nearly as much of that money as I gave to those people who brought me to the banks. First of all, I want to tell the court I am sincerely remorseful for committing these crimes, and I accept and take full responsibility for that. I'm sorry to all the parties I have hurt because of my actions, not just the owner of the account, but also the bank. It was a stupid and selfish crime motivated by greed and desperation. I had just had the second of 2 strokes, diagnosed with a brain aneurysm on my cerebral artery. And my girlfriend, who I was living with, broke up with me, and I was living in a tent. Your Honor, I'm not saying these things excuse my behavior. I'm just trying to show what my state of mind was at the time. Regardless, Judge Morgan, I shouldn't have done it, and I again apologize to all I've negatively affected. Since I've been in jail, both of my parents have died. And I wasn't able to attend their funerals or say goodbye to them. I've done my best to show my remorse by paying the $5,000 in restitution before sentencing today. Please, Judge Morgan, if you would consider all these factors and show me leniency by giving me a state imposed sentence, I will remain law abiding and never find myself on the wrong side of the law again. I'm 60 years old. My health is failing. I should be spending my time with my daughter and grandchildren, not sitting in jail for being stupid and stealing from hardworking, honest people. Please, Your Honor, don't send me to prison.
Mr. Standiford, actions have consequences. And you're sitting here before me today to face your consequences for your actions. And your actions, we're not just talking about the actions that precipitated the case here before me. We're talking about your actions throughout the entire life. And that would include the 47, well, that would be after today, convictions for criminal charges that you face throughout your life. When the court looks at sentencing, there's a whole lot of factors and a whole lot of things that I have to look at. One is correct, it's remorse. And I see your tears and I heard your tears. I believe your tears are more of the fact that you got caught and you're where you are here today. Okay, not the fact that you feel remorse for what you've done, and the impact and the consequences on others. Because your attorney made a statement here today too, that, well, you've paid the $5,000 and that will make the victims whole. That will bring the victims and make them whole. Both of those are incorrect statements. Okay, because the fact that I don't believe you paid the $5,000. I don't think that came from you. I think, and stop, lady, I'll kick you out of my courtroom. Stop shaking your head. Stop talking. This is not for you to make a statement. I don't believe that money was from your money, or if it was your money, then that was money that you've taken and stolen from other people. Because you've taken and stop talking. You've taken and stolen money from other people. Here, it was a total of $22,700.75. Granted, you didn't get all of the money. All right. Miss Blackerby got some, this unidentified individual who may have perpetrated this criminal empire of making checks and doing these things. And I'm not saying that this is an empire, a criminal empire, but it is this is a well thought out plan. So one, I don't believe that the $5,000 was actually your hard earned money, sweat, blood, and tears money. I don't believe that is true. Secondly, the victims aren't going to be made whole. The bank may have gotten all of its money back, may have not had to pay out for your actions and your conduct. That doesn't make the victims whole. We still have an insurance company that's out money. Yep, it is a large corporation and it's an insurance company, but they've paid all of the money out for your actions, for what you got to benefit from, and Miss Blackerby did, and this other individual, what they got to benefit from. But again, the insurance company, the community bank, and the actual individual who you stole the checks from may not be you personally stealing the account information, but you were involved in taking the money from him. So there's multiple actual victims. But then we're looking at, this is not only those three individuals, those three victims here. Society, the public, the community, they're a victim too. Because just because this is a financial crime doesn't mean it's less serious than something else. You may not have went and beat the living life out of an individual and left them there to die on the sidewalk, but you have been a leech on society, and you have went and taken what you want when you want, and to get money for your habits, for to pay for your lifestyle, to pay for your food, for whatever. You have went and you just take what you want. You don't work for that. And so society is actually a victim as well. This impacts every single person in here. The fact that somebody takes a check and steals money from someone else and uses it for whatever you want to use it for impacts everybody else. It causes our fees, our things, everything else to be inflated. Our insurance deductibles or payments and our premiums, all of those things, it has an impact on everybody. And I hear your words and I saw your tears. But again, I don't think you're crying for the remorse that you have done, and you're realizing the impact you've had on people. You're crying because you're in Orange and you've been in Orange for 7 months, and both of your parents unfortunately died while you were incarcerated, and you got caught. And you face prison for a very, very long time. And if I did the calculation, and I did, and I look at all of the charges that you were charged with in this case and the maximum possible penalties, and I compared that to this baby sweet deal that you were given in your plea agreement. If you went to trial and you were convicted on all of these counts, which there's pretty substantial evidentiary information, but there's no guarantee you'd be convicted on all of the counts. But if you were, you faced 70 years of incarceration, 70 years, 35 years of initial confinement, 35 years of extended supervision, which could equate to all of that time served behind bars if you're not able to figure out how to be supervised on extended supervision. But with the deal that you got, the maximum exposure that you have hanging over your head is far, far less. It's only 16 years, a maximum of 8 years of initial confinement and 8 years of extended supervision. So you went from 35 years of initial confinement, 35 years of extended supervision exposure, down to 8 years of initial confinement, 8 years of extended supervision. That is a tremendous deal. You haven't done much to show that you want to change your life. You're 60 years old. You've been living in the same old rut pretty much your whole life. You haven't done anything to improve yourself or improve others' lives, quite honestly. You've just kind of get by to get by. So when I'm looking at all of the factors and taking into account that I do need to protect the public from further criminal activity, you do need treatment and programming that I do feel is only able to be provided by behind bars. And the fact that I do believe that if I put you simply on probation, it does unduly depreciate the seriousness of the offense, that prison is necessary here. You have $5,000 paid for restitution. The court is ordering $5,000. Well, it's a total of, the court is ordering the $22,700.75 in restitution. The $17,775 is owed to the insurance company. Whether or not they're going to get paid, court looks at the other victims first. You have $5,000 down, so that covers at least the community bank. As it relates to the felony counts, I'm assessing $518 in fines and fees per count. That must be paid in increments, as well as towards the rest of the restitution, $100 per month until paid off in full. That will start when you are in prison, and they can take it out of any and all accounts that you do have in prison to pay for that at the DOC rate. With regards to the sentence that I will sentence you for your incarceration time, because I do believe that this is a very serious financial crime. I do believe that you need to be punished. I do believe that you have not yet learned your lesson and you have not learned how to rehabilitate or to change. I do believe that you got a significant deal in your plea agreement that you've reached with the state, that I am going to sentence you to, as it relates to 23 CF 124 count 1, to 3 years of initial incarceration and 3 years of extended supervision. As to 23 CF 124 count 11, the class G felony, I'm sentencing you to 5 years of initial incarceration and 5 years of extended supervision, and I'm making them consecutive to each other. That means you sit one, then you sit the other. I will make you eligible for the early release programming. For the substance abuse programming, you are not eligible for the challenge incarceration program because of your age, but for the substance abuse programming, you will be eligible, but not until you first sit your time for count 1, the 3 years in and the 3 years out. The court is going to give you 212 days of jail credit. Conditions on extended supervision: absolute sobriety, no use or possession of any illegal drugs, substances, or paraphernalia. You may not use or possess any checking accounts or have any checks provided to you. You must have gainful employment when you are released, and you must have stable housing. And whether or not that's through a group home or something of that, the court doesn't care, but you have to find some type of stable housing. You have 20 days to appeal. Should you fail to appeal within 20 days, you do lose that right. This is a felony: no use or possession of a firearm for life, no voting in any election until your civil rights are restored. I do believe that this is necessary to protect the public and to protect the public from you, Mr. Standiford. Do I believe that there is somebody else out here who may be the mastermind? I sure do, but it doesn't diminish your conduct. It doesn't diminish your part. You knew it was wrong, or you should have known it was wrong each and every time you engaged in this, each and every time. And the fact that you didn't have any little angel sitting on your shoulder telling you that it was wrong is very indicative of the fact that you need to engage in a type of criminal thinking program. And so I'm also going to order a thinking for a change or breaking barriers program for you to engage in. Hopefully, by the time you are released from custody, that you will have found ways to change your life and to figure it out. Because now that you've re-engaged in contact with your daughter and your grandchildren, hopefully you can figure out how to keep that. I'm sure it is been a long while for both you and for your daughter.